Welcome to Thoughtful Planning, the place where real conversation, expert insight, and a touch of humor meet to turn our end-of-life uncertainties into self-assurance. I'm your co-host, Santiago, a history buff and a big kid at heart.
And I'm Honey, your guide through the intricate dance of planning with care and a whole lot of warmth. Every week, we're here to turn those intimidating "are we ready" moments into confident "everything is under control" moments. Today's journey is one you won't want to miss. Hi, welcome to Thoughtful Planning. I'm Honey.
And I'm Santiago. So when we were doing research about the topic we're talking about today, we came across Caring.com and their 2024 will survey. And they found that only 32% of Americans have a will. And that's really a 6% decrease from the previous year. And the whole reason that we do our podcast is to normalize the conversation of death and to help others understand what's involved. We hoped that we're going to change that number to get it higher because there is a lot of things that we need to do when it comes to having a will and trust. So our essential question today is, how important is it for you to have a will or a trust?
Great question, babe. And luckily, we have an attorney to help us answer that question today. But first, we have a disclaimer to let you know this is not legal advice, and it's important for you to consult an estate or elder law attorney in your state for your specific situation. So I'm excited for our guest today. She is the founder of Norton Estate Planning and Elder Law Firm, LLC, in Indianapolis, Indiana. I came across her business while I was scrolling on Facebook, and there was this ad that popped up that said, "Your 4-step probate guide." And it caught my attention. So I added my email in to learn more. So I wanted to know what it was like to go through this whole probate process. And so I reached out to our guest for an interview, and she said yes. So without further ado, Jennifer Norton, thank you very much for being our guest today on our podcast.
Thank you so much for having me. I'm excited that you guys are putting this topic at the forefront of people's minds and getting people to focus on it because it's very, very important.
Yes, for sure. So would you please share with our audience why you decided to become a lawyer?
Well, it's funny. I never thought I was going to be a lawyer. I actually thought I was going to be an accountant. And so I graduated from Indiana University in Bloomington there, and I have a degree in finance actually from their business school. And probably my junior year, I started having a panic attack from going through all my internships. I was public accounting, I did private accounting, I did not-for-profit accounting, and I just was not happy. And so, I thought, okay, maybe I should just go to law school. They say attorneys can do anything, and I can just figure it out when I get there. So, and then I convinced my best friend, Irene, I said, hey, we don't like this finance stuff. Let's just go to law school. And she literally only applied to one school. And I was like, hey, let's share schools. And she's like, no, I only applied to one. And I'm like, oh, where? And she's like, here. And I like, did you get in? She said, yes. I said, oh, well, that looks like where we're going. And so that's how I ended up actually in law school because I needed to buy myself some more time. I really didn't like the profession that I was in. And the funny thing is I practice law and she doesn't. So she really didn't want to go to law school, but she's a great friend. And so that's where I ended up in law school. My uncle always said, though, that he always thought I should have been an attorney and that this was my field. But I just like numbers and I like certainty. And so it's just happenstance that the worlds collided, the gods came together, and I ended up in law school and an attorney.
That's awesome.
That is, and here we are.
And here we are.
So, Jennifer, for our listeners that may not fully understand the topic, would you please share what a will is and what is probate?
Yeah. So a will is a set of instructions that tells your property where to go. Okay. The person that does the work is called your personal representative. And it basically is a document that allows you to take control of who you want your beneficiaries to be, especially if you want them to be people that are not a blood relation, right? Your state statute will distribute your assets to your next of kin And every state is different. For instance, in Indiana, married people think that the assets will pass to them by law. Well, in Indiana, if you leave assets solely in your name with no joint owner and no beneficiary listed as the spouse, then the law will pass the assets 50% to the spouse, 50% to the children. And so the probate process is there to make sure that assets, like when a death occurs, a person's final debts, taxes, and expenses are all wrapped up prior to a beneficiary inheriting. And then someone has to get appointed over the estate in order to do that transfer, because the courts can't be in everyone's home. And most states like the person to be over the age of 18 and not committed a felony. Now, if they have certain felonies, then it may be up to the judge, their discretion on whether or not that person can serve. But then once they're appointed, they publish notice in the local paper to allow creditors to file into the estate. Because most families will go on this morbid scavenger hunt trying to figure out what you own, where is it, and what to do with it when a death occurs, because people don't leave a list of what they financially own. And thus the court says, well, come over here and we'll guide you through the process. But if you don't know what they own, you probably don't know who they owe either. And so we have to run notice in the local paper. Every state has a different length of time that it has to run. And then for a certain length of 90 days, 6 months, a year, depending on your state, there's this window of opportunity for the creditor to file into the estate. And they have to show evidence of the debt, swear under penalties of perjury that the debt still exists, and pay a filing fee to the court in order to kind of perfect their claim. And then once that it's called publication. Once that publication period tolls, when we get to the end of it, then theoretically we should know everything a person owns and everybody the person owes. And then the court wants us to pay those people off and then distribute according to your state statute. And so, like I said, in Indiana, if you don't have a beneficiary or you don't have a joint owner on the account and you're married, they'll pass the assets 50% to the spouse. In my stories, the husbands always die first. I tell them, do what you want to do, men. You're going to die first in these stories. And so we would cut 50% to the spouse, 50% to the children. You get a will to say, actually, I don't like that distribution. So your state has a default, and wills are there to tell the probate judge, I don't want to do the defaults. I want this pattern of distribution. And so most people don't realize that wills do go through probate because they're there to guide the judge if you want something in the alternative to your state statute.
That was a lot of information. Very good.
That's what all the clients tell me.
And very good information.
No, that's great information.
So would you share a story or stories of a time when a person died without a will and you helped the family go through probate?
Yeah, absolutely. I would say about 40% of my practice is actually with probate administration. And essentially what tends to happen is the family calls our office and they are lost, confused. They assume, oh, mom or dad said they had life insurance for the funeral, but there's no real registry where we can dial that information up. And then sometimes what happens, I've had cases where the family member has a small policy, but they made a beneficiary on the policy. And they told that beneficiary, or at least they told the family, we're going to use those proceeds to pay for my funeral. Well, what happens is when you make someone the beneficiary on a policy, it's their money. So they don't have to use the money. So we've actually had situations where the beneficiary of the policy doesn't want to use the money to bury you. So we had a situation there where a beneficiary of a policy who happens to be a child did not want to use the proceeds to pay for the funeral. And there's nothing I can really do to force them to do that. The probate process then gets initiated to see if we can corral other financials from either bank accounts, investment accounts, maybe the sale of a home, and see if we can to find some funds to kind of carry out the person's final homegoing services and then distribute to the heirs. The problem, however, especially in blended families, is it gets real messy, right? If you leave all the assets when you're going through the probate process, all of the assets unfortunately have to get distributed to the surviving spouse. But if they don't have children together, then sometimes the person that died will unintentionally disinherit their own family. And those are sometimes the heart-wrenching stories where you think that, oh, if I do this, these are the outcomes. You're assuming the outcomes. And unfortunately, when you get behind the scenes and you actually do the real work and apply the law in blended families, I tend to find a lot of families unintentionally disinherit their own children when they leave assets directly to their spouse. And unfortunately, if they have no children together, then there's no legal requirement that the surviving spouse has to send any of the funds back to the deceased person's children. So that's the kind of I'm not going to say the horror stories, but the horror story of probate is that sometimes the outcomes can be very predictable, but when they're unpredictable or not in line with what we believe the deceased person would have wanted, then that's where it gets kind of heart-wrenching, to be in my shoes trying to deliver that news to the family to say, I'm sorry, you're probably never going to be able to inherit from your loved one's estate.
That's very interesting. I didn't realize that. And so what would you recommend to someone who, if they want to leave funds for their funeral, what is your advice to them instead of saying like, okay, I expect this beneficiary to, use the funds to pay for the funeral?
Yeah.
Would you recommend like them to instead do like funeral pre-planning or have like an
Yes.
account set aside for funeral funds?
Absolutely. So you can pre-plan with the funeral because they have funeral trusts. So then you're kind of like prepaying and your funds are held there. And I do believe this is federal, but I know for sure in the state of Indiana that even if that funeral home went under and you prepaid for that location, you can take your funds and your contract to a different location. And then maybe they may try to upsell you on more services, but your money's still good. And the other thing that you can do is on life insurance policies, if you pre-plan, you can go ahead and assign the funeral home as the beneficiary on the policy. So that way, again, your services are covered and you know exactly what services you're going to get because you plan them. And then the excess can then go to the family. So even if the services cost less than what the policy is worth, your proceeds don't all get paid to the funeral home. The excess is then distributed to the family. And then the third option is you can always set up a trust-based estate plan. A trust is very similar to a will in that it's a set of instructions, tells your property where to go. The persons that run the trust are called the trustee. So if you set up a trust, you're considered the trust maker, the grantor, settlor, and you're also the trustee. You're the boss as long as you're alive and you can think well. And so with a trust, it can avoid probate. I'm still an attorney, can, not will, as long as you retitle all of your accounts or make the beneficiaries reflect the name of your trust. Because you can call a trust anything. So you could call it the legacy trust. You could call it this, a scripture or whatever, your family name, or just your surname, Jennifer Norton Living Trust. And so you take that name and put it on all of your accounts in the ownership position, or if it's a retirement or life insurance or some type of annuity, in the beneficiary position, you would put the name of the trust. And then the trust, within the trust, this stack of instructions, then you would say, I want the proceeds from X policy to pay for my funeral, or I want my trustee to use whatever funds are available, but you pay my funeral expenses off the top. So then you're not tied to one specific policy. It's just a duty of the trustee to make sure the funeral gets paid. So those are typically your three options are, yes, pre-plan and you can prepay. You can irrevocably assign or revocably, but usually it's irrevocably assign your proceeds, your policy proceeds to the funeral home, or you can set up a trust and then within the terms of your document that's called the trust, lay out how the funeral is to be handled.
Okay, two questions.
Yeah, go ahead.
On the second option where you mentioned,
insurance as the beneficiary.
Right, you put the funeral home as a beneficiary. Then you, like a while ago, you mentioned like if that specific funeral home were to go under, then what happens?
So most states have I don't know, it's like a funeral trust. It's like a I don't know if you call it like a community trust, but basically the funds are pooled when you prepay. So the funeral home doesn't own the funds. They're in an investment vehicle. And so
Okay.
that investment vehicle is a large institution that holds your account, like your account. So that way, if the funeral home goes under, you're not losing your money because your money isn't with them. It's with the institution, because then they're, of course, making money off the, you pre-playing, they're investing it, etc. But then if they go under, then you want to switch locations. Then when you tap into your funds, it's not through the funeral. It's actually through this institution that's custodying your funds.
Got it. And then on the third option, where we could write it into the trust, the directions of how those funds should be used,
Mm-hmm.
there's no way to do that in a will, to write these instructions in a will.
You can write it in a will. Okay. The thing about what most people come to my office, they don't want to go through probate, and all wills go through probate. And
Right.
so in certain states like Indiana, you can actually put beneficiaries on all of your assets. So you always can put beneficiaries on life insurance, retirement plans, and annuities. And you can also put beneficiaries on bank accounts, stocks, bonds. That's called TOD, transfer on death, or POD, payable on death. Well, in Indiana, we can even put beneficiaries on our cars at the license branch if it's paid off. We can put them on real estate. It's called a transfer on death deed. So the minute a death occurs, ownership would actually pass to that beneficiary on the deed. Someone just needs to let the institution or the recorder's office know. And so you either file an affidavit with the recorder's office saying that the person has died, transferred into the new owner's name, or if it's like an institution, you give them a death certificate and then they will pay it to the institution. So if people want to avoid probate, you're going to find a lot of times what they'll do is they'll just put beneficiaries directly on all of their accounts. And then the will is there as a backup. What if my long lost relative leaves me an asset? Or what if some class action lawsuit? They got class action lawsuits going on with perms right now, Listerine. I saw one for like Roblox. I mean, they always got class actions going on, right? So if a check were to come later, the will would direct the funds, especially if you did something other than the state default. So say you did one in Indiana to go all to my spouse. Well, you would need to do a will and have one documented so that if later funds came in, then we could give those proceeds to the spouse. But a lot of times in Indiana, most families will simply put beneficiaries on all of their assets so that they can avoid probate. So if you never have anything touching the will only controls things that are left solely in your name or to your estate. And so if you put beneficiaries on everything, nothing would ever touch the will, and thus we would not have anything to pay the funds. Now, if you did say change a policy and remove the beneficiary so that it would go through the estate, then yes, the will would control it, but then you'd have to go through probate. And most people don't want to pay the fees associated with the attorneys, the court costs, because every state is different. But regardless, probate is expensive, sometimes unnecessarily, because there's no organization. People don't know where stuff is at. And so it takes a long time to kind of, get through figuring out where everything is, and people are grieving, etc. Mm-hmm. So when you try to use the will to do the distribution or to handle the funeral expenses, that means you have to put something through the estate to go through probate. And most people don't want to go through probate. So that's kind of your catch-22 about just putting it dead into the will, especially if you want to avoid court.
Okay. Makes sense.
Wow. That's a lot. I got a couple good quotes though. All wills go through probate.
There you go.
Probate is expensive.
It is. Yes, it is.
Okay. So, what's the longest probate that you've been a part of, and why did it take so long?
So my longest probate. So in Indiana, once you get through the publication period, so when we have to publish notice in the paper, we have a 90-day period. Most states have longer. Like I think Texas might be 6 months to a year. So in Indiana, our courts actually like to see you wrapping it up after year one. When you're getting to year 2 or year 1.5, 2, they're getting real antsy, like what's going on over there? So the longest I've ever had personally is probably about 1.5 years. And that was mainly because um, family drama. There it is. I said it. Just the drama. It's, people expect they're supposed to get more than they want, or I don't trust that she's doing her job. And so let's go to court and let's see if a judge thinks otherwise. And people don't realize that judges don't do what you think they do. They're not like overseeing every nickel and dime. Like what they're doing is they're just making sure that people have an opportunity to be heard, but they're not combing through every step that the personal representative or the administrator is taking. They're just, anytime you want to do something, if I want to sell the house, if I want to distribute the money, they'll set a hearing to allow an objection or to allow evidence in if you think that someone's trying to give away the house for, less than fair market value. But you can't just mosey into court. You have to be represented. So they want you to put some skin in the game, meaning you have to go get an attorney. And so that's sometimes, if you get an unreasonable attorney on the other side, then that's where it gets kind of a little sticky. And the other times that I see that my cases drag out longer is when, say, people are in long-term relationships, but they don't get married. That's one I got going on now. And the kids assume that the assets should come to me, even though we've had this longtime partner. And I actually took proactive steps to do a plan for that partner. Well, they can still object, right? So we're in court for nothing, right? The man, like we have a situation where the man, he didn't die of dementia and he did his will 2 years prior to his death. But we're still in court where the children, the beneficiaries, are acting as if he was influenced and no. Unfortunately, people are allowed to make bad decisions, one, or two, beneficiaries, you're not entitled to your parents' estate. I don't know why people don't get that through their head. Just because that's your parent doesn't mean you're entitled to their money. They're allowed to do whatever they want with their money. And sometimes that means including people that you don't want to receive anything. And so that tends to draw out the probates, is the drama. And so if you want to get around it, my advice is always to just have the difficult conversation today, because whoever people believe will cause the trouble, I'm here to tell people you are absolutely correct. They are going to do it. And so you might as well bring everybody to the table, lay down the law, and then go put it in legal writing. So then everybody knows, and it's not this whole telephone, like mama said to me and daddy said to me, and everybody's got these different versions of the story. If you just get around together, Thanksgiving's coming up, everybody sit around the table, and this is the plan, folks. And if you have an objection, there are two options. You can get on board, or I can cut you out. Super simple.
I like it.
Yeah, sometimes a death brings out the ugly in people.
Oh my goodness. Yes, it does.
So I think you answered this, but I just want to make sure I got clarity on it. Can a family member go through the probate process without an attorney? I think you said no.
Most states, no. They want them to be represented, because then, how you were asking me, like how long they drag out. Well, it can drag out even longer when people don't know the rules. So they prefer that you have someone professionally there, so that you may think something should be fair, but the rule is this. And so they prefer that you be represented. Even if you're a pro se, you know how you see in criminal offenses where someone says, I'm pro se, they still have an attorney like at the table a little bit, just so they don't get so off kilter that, sometimes those people, you can't speak reason into them. And so in my case, I really like it if a beneficiary is upset and they go get counsel, because then there's a reasonable mind and a reasonable head at the table, as opposed to someone who might be doing something or thinking something irrationally. And I'll give you an example of irrational. So we've had situations where parents would come in and say, oh, unfortunately, my child died and I want to administer the estate so that I can get all the proceeds. And I'm like, well, wait, but they have kids. And they're like, but I'm the mom. And I had one literally, it was a father. And I said, but your son had kids. So the kids are the beneficiaries. And he's like, but I'm the dad. And I said, well, if you died, then who inherits your money? And he said, my kids. I said, well, why doesn't that logic work for your son? So that's what I'm saying, where people get really illogical about death and money. And then when you face the truth, then he hung up on me. So
Ouch.
Well, no, I mean, yeah, we've seen it. Both of us have, and it's that's why we're doing what we're doing. And we've had those hard conversations with our children. Said, look, this is
that's
it.
good.
This is
That's
what you
really
got.
good.
Mhm.
So, on average, how much does a family pay a lawyer to go to court and get through the probate process? Are
You
there
know,
other fees that might be assigned to family members?
well, yeah, it can be. There can be other fees. So typically the estate pays the attorney that's representing it. Everybody else, if you have your own attorneys, then you're paying out of your own pocket. So the person or the beneficiaries that go get their own separate attorneys, they lose twice, right? Because the estate's going to go down, and then whatever they are, doing with their attorney, they have to pay out of their inheritance or pay out of their own pocket. And so their fees get reduced even lower. And so some states it's statutory, like in Florida, you can look to the state statute to tell you. In California, they have their probate fees in the statute. Some states are like Indiana, where it just has to be reasonable, and what's reasonable, right? And so it can be very subjective, but I can tell you in Indiana, you'll find it as low as $2,500, but it can go as high as 10,000 or more, especially if you're doing it unsupervised. So there's two ways to run an estate. It can be unsupervised, which just means all the beneficiaries agree that this person's going to serve. The person that's serving, affirms to the court that they're going to follow the state's law. They're going to report what's required, and then they will close the estate efficiently. And so the court doesn't have to lord over the unsupervised because they're tasked with listening to the attorney to usher them through the process quickly. When you do supervised, that's where you're saying, okay, the court is going to oversee every major activity, and thus you have to petition the court for approval to do it, such as sell a home, sell a car, distribute the funds once they're received. And then you have to report back copies of the checks and copies of the bank statement showing everything cleared, showing the bank statement went to zero. And so when you're in the unsupervised side of things, the fee structure could be, it could be unlimited. It could eat up majority of the estate if you have the contentious beneficiaries involved.
Wow. um,
That's kind of crazy.
That's a lot of money.
Yeah, it is. It's like the Wild Wild West some days. I'm like, a lot of people think, oh, estate planning, it's so boring. I'm like, no, we're like family law on like steroids. Like, if you get the wrong individuals involved.
Yeah.
Well, people think that a trust is expensive. It might be a little pricey up front, but when you look at the end cost.
That's exactly right. You hit the nail on the head. A trust is it's almost like it's preventative maintenance that you're doing. You're starting out behind the ball because you're putting out a little bit more money. And then if you're maintaining the ball, just like when you maintain your finances, you should be updating and revisiting your trust. And a lot of my friends, we all have maintenance programs for our trust clients so that they can update their estate plans and fine tune it as the beneficiaries' lives, go one way or the other. We need to adjust, especially if they have grandkids or marry in a certain way that maybe someone doesn't agree with, or they, a beneficiary is struggling with dependency issues, or someone has special needs, then the trust should be adjusting. And then because you do all the work ahead of time with a trust to avoid probate, as long as you retitle all the assets, which is called fund the trust, then when a death occurs, there's no probate, right? So you take out that huge expense. You do have to file it's called spread the will, file the will with the court so that they know that, where a death has occurred, but we're not coming through with a probate. But if something comes in, later discovered asset comes in, then this is where it should be distributed later. You're able to save all that cost and headache. And basically with the trust, we just update the trustees that are in charge because of the death. And then we present an affidavit, affirming the trust existed. The original trustee died. These are the new trustees. And then here's the paperwork from the trust. Here's copies of like excerpts from the trust. Then we give that document to each of the institutions, and we're golden. Now we're just following the rules of the trust. So you save tons of time with a trust on the back end. So we've administered a trust in 30 days. Mind you, with a probate, we still got 60 more days for the creditors to file in before we can really get started. So yes, a trust will save you. It is a little bit more expensive on the front end, but like you said, on the back end, way, way, way less expensive. And then you're maximizing the inheritance for your loved ones and your beneficiaries.
Right. And so then you said, so then there's no public notice then.
Correct. Yes.
Right.
Yep, because wills are public. So I can go downtown and pay $1 per page and find out all about the financials, who the beneficiaries are. I can get copies of all that. But with a trust, you won't, because all the will says is, I did a trust. And so you go down and get a copy of any of the proceedings for a trust-based plan, and all you're seeing is who the trustees are of the trust, but you don't get any of the terms, any of the financials. None of that is included.
Nice.
Cool.
Yeah.
All right. So I've heard people say that they have godparents and for their kids, and so they think that when they die, like they don't have to do anything with their kids because they have godparents. So would you please let the listeners know if this is true, and can you tell us what happens? Like, what happens when there's no will and kids are involved?
That's a great question, because it's a big missing gap. And unfortunately, with the violence that's going on in today's society, you see a lot more young people dying. And if you don't have a plan, then you have to go to court for a guardianship. And typically, when you have minor children, the biological parent is the next natural guardian of the child. And if that could be good or bad in some people's situations. And typically in the bad situations, you'll find that they only want to be the guardian for the money, right? Mm-hmm. And so, but when you do your estate planning, you can separate who's the guardian is the person that makes the legal decisions on behalf of the child. What school are you going to go to? Who do you live with? Because they don't have to live with the guardian. Who do you live with? Can you go on that field trip? Who's your doctor? They're making all the legal decisions. The money, because they're minors, is held in a trust. Right. And if you don't do anything, the default under most state statutes is when the child becomes the age of majority, which could be 18 in some states or 21 in others, then we're going to cut a check to that child and tell them good luck, because we can only hold on to the check until they reach the age of majority. No rules, no restrictions, no preventative language to help set them up for success. And so because of that, when you go through the guardianship process, if the natural parent isn't a good fit, then you're going to end up in litigation, because you have to prove, which I've had to do before, you had to prove that the natural parent was not a good fit, where I've literally had to I filed a 100-page document of someone's credit report, because to prove that and it was a lot of money. I mean, it was almost $750,000. We couldn't have this money go to the parent because we already knew the outcome of the funds based on their prior history. And so if you don't select a guardian and then be intentional about who runs the money, then you could literally have made all of this and, grown all this wealth for not, right? And your children won't even experience it. So what you have to do as a parent is, in the will, you name who the guardian will be. And if you do a will-based plan, then you also will have a trust set up, and then you would pick who are the trustees over the money, which doesn't have to be the same person as the person that you're nominating as the guardian. Or if it's the natural parent and you don't want them to run the money, then you can name the natural parent, have a backup, but then assign different people to run the trust. If you're doing a trust-based estate plan, you'd still have a will, but it's known as a pour over will. It says, if I forget anything outside the trust, go get it, pour it over to the trust. That's why the will in a trust that's why in a will with a trust-based plan, they only list the trust as the beneficiary. And so in that will, you just name who the guardian is. And then in the actual revocable living trust, where you have your little trustlets for your beneficiaries, then you would name who runs your trustlets. And so that way, again, we don't have to end up in court for a guardianship, because now you've already made the decision of who's making the legal decisions and who's running the money. And again, they don't have to be the same people. You can create teams. You really can craft it to make a plan that works. And that doesn't mean it's going to match your friends, right? So you put your teams together in a way that makes sense for your family. But you really do want to make sure that you get that plan. Now, in some states, you can even do what's called a standby guardianship. So in Indiana, we can create a document that for 90 days, you're giving authority to this person or persons to be the guardian and make these decisions until a permanent one is appointed if you failed to do like the will or the trust. And we've done that in kind of an emergency situation where we had like a client that was getting ready to go into surgery, and then we didn't know necessarily how the outcome was going to be. And so we wanted to make sure that we had a guardian in place, at least for the 90 days. We were hopeful that it was going to be a positive, surgery or what, and it was. But we did go ahead and do a standby guardian just in case. And then when she came through, we had some other health issues that now we have to move for permanent guardianship for the children. But you do want to get a plan because there is no default to godchildren, godparents being the one that's going to step up. It's actually the judge would determine who is fit, and that's where you get these legal battles over who's going to be the person, and you just don't want your kids having to go through that, because in some states they will allow, depending on the age of the child, they'll let them testify to who they want to live with. Mm. And that could be good or bad too, because they want to go with the fun one.
Right. Now, what if, there is no will, right, or no trust, person dies, and now there's the kids, and there's, there's a grandma or a grandpa, and the kids, they go into foster care or where do they go?
No, not per se. If someone in the family is willing to step up and kind of house the children, most states will allow that. And they may have someone from like the Department of Child Services or whatever they call it in their state, may have them come in and do a home assessment just to make sure that the child is safe, etc. But typically they will allow family to step up and be the temporary guardian, if you will, until you get to that court date. But again, all of that can be thrown off kilter if someone's like, oh, well, they've been, and it could be just an accusation. It doesn't even have to be true. Oh, they've been accused of child molestation. And next thing you know, there's this whole investigation, snatch the kids out of the house. And now they may be in foster care or something like that, unless some other family member or friend wants to step up and, house them temporarily. So it's just one of those black holes, because you don't necessarily know the outcome, because you don't know who the people are and how they'll, respond. But typically, because like say it is the grandparents, well, then someone might come in and say, well, they're older and they have mobility issues and they can't keep up with the children. They're running circles around them. You know what I mean? So it's all that plays into part. And then of course you got your judges, right? So you can catch a judge on a good day or a bad day, someone that's had a bad history in the foster care system that you don't know about. And so they bring their full self to the hearing. They try to be very neutral, but you can't separate who you are and your life experiences. And so we look to judges to bring some of that wisdom and experiential kind of intellect to the conversation and to the hearing. And so you just don't know who you're going to go before either on a specific day and what their background brings to that case.
Interesting.
Wow. Yeah.
That's scary.
It is a little bit. So I'm glad our kids are a little bit older. So
right.
They're both out of the house now. So it's
much easier.
So let's talk a little bit more about money. So if someone's died and they have those outstanding debts that have been either, identified in the 90-day period, or they know that they have debt and it can't be paid by the estate, then what happens to that debt? Does it go to, like assets to the spouse or family member to have their payoff balance too?
That's a great question. No, the debt actually stays with the estate. So if there are no assets in the estate, say you put beneficiaries on everything so that the contract is effective the minute the death occurred, then that means those assets are the ownership belongs to the beneficiaries. And so there's nothing in the estate to satisfy that creditor. So typically the creditors will then write off the debt, or they'll try to sell the debt to those other kind of credit companies that call you. And so we get a lot of those that we have to put on do not disturb, like, because they're calling you and they'll tell you, they start off the sentence, you're not responsible for the debts of your loved ones, but then they talk you to death. Right. And then by the end of the conversation, they're trying to get you to sign on or to assume the debt. That's only happened to one of my clients. And I told her, do not sign anything. But see, what happens is those creditors will go away and then they come back. And so she felt so much pressure. And I said, why? You should have just told me your representative and called us, because we would have told you. But now you're on the hook for it. You signed an agreement to assume that debt. And another situation we had, they came to me to hire me after they had already cut a check to them. So when you're the recipient of proceeds from like life insurance and retirement plans, you should never pay that money to satisfy the debts and the creditors, because that's yours as a beneficiary. It's your money. It's not a product or an asset of the estate that has to be used to rid the estate of a creditor. The only creditors that tend to stick around are cars, right? Because you don't get title to the car until you paid off the debt. So those people, you try to they really just want payment. So you just give them a call, tell them whether you want to keep the car or not. And if you want to keep it, they'll just say, well, keep cutting us a check and all is good with the world. If it's a house, remember the mortgage is a lien on the house. So they want to be paid back first before, if you were to sell the house, before you get your proceeds. And so you can't get around mortgage companies because they have a lien attached to the house. So as surviving spouses, you're typically eligible to just assume the debt and continue making the payments, especially if you didn't help with originating the mortgage. And then with beneficiaries, it depends. And we tell all of our clients and prospective clients, if you have a mortgage on your property, it's best that you contact that mortgage company to find out, if I died, can my children take over this mortgage and continue paying it? Or are they going to have to qualify on their own financial strength? Because if they can't qualify on their own financial strength, then we need to come up with a plan to, if we want to keep the home, we got to come up with a plan on how it's going to get paid. What you'll find, though, is most people just won't tell the mortgage company. They'll just keep accepting the checks. That's usually what happens is, as long as the checks keep coming, they're not too upset. But when they do figure out a death has occurred, we had a client in our office the other day. They gave them the check back. They sent all the money back. So it just every mortgage company is different, and so it's best that you as the originator of the mortgage, you should call in and find out if a death occurs, who can take over and how. And then two, I always tell the clients, go ahead and put your children on as authorized representatives that can call in and find about the mortgage, even without reporting the death. Right. So that way we can kind of at least get lay of the land before we have to make decisions and notify the mortgage company. And so that puts them the family in a more position of power, because the mortgage is only in your name. So when a death occurs, powers of attorney are no longer valid. So you can't submit that stuff. So they would either have to hack your account, right? And, try to go through your email if you even have it set up on email, or create an account, because they won't be able to get information about the mortgage balance and stuff like that unless you make them authorized representatives. And I tell people all the time, your kids aren't voluntarily paying your mortgage, so it's okay. I don't know any kids that sign up to voluntarily pay your debts. So putting them on the mortgage to get access to information, no harm, no foul.
Right. And you're just saying to put them on the mortgage as like a contact, like they could talk
Correct.
to, not as on the title, like
on the actual, like they're not obligated, like an obligee to pay it. Yeah. They just can call in, kind of like your utilities. Like when you put the utilities in your name and you have to put your spouse on there so they can call in, same thing.
Gotcha. Yeah. Okay. Now, what about, it's just a little bit, same question, similar, but if, let's say that I pass away and I have a big medical debt.
Okay.
Is that going to affect my husband then?
So it shouldn't unless he signed on it. So like sometimes when spouses like go, say they have nursing home or rehab care, they try to get both spouses to sign. So that way, when the first spouse dies, then the surviving spouse is still on the hook. You know what I mean? For the balance.
Now I think
Uh,
I know it. Hold on,
Go ahead.
because now when I go to the doctor, that's what they say. Because I do read the paperwork and it does say
Yeah.
that, now that you say that.
So they're trying to get the
Okay.
spouses to be obligated because technically under the law, you were serviced, they weren't. You agreed to the repayment. You're not here. There are no funds to pay them, so they have to write it off. Yep.
I'm not signing anything at the doctor anymore.
Yes, especially if it's a big procedure, sign nothing. And matter of fact, you scratch out the spouse is responsible in that fine print. Yep.
Well, we're pretty fortunate because I'm retired military, so we
Oh,
don't get
good.
a
So you
lot
got
of that.
great benefits. Yeah.
Ouch.
Awesome.
Have you come across a situation where the family member could not afford to pay for death certificates and there was no money left by the deceased? So, if yes, like, do you know what happens in that
Yeah.
situation?
So typically, when a person has a very small estate, most states have this process called small estate administration. So it is a probate, but it's a small estate administration, meaning the courts are overwhelmed. People die every day, so everybody can't come to court. So they set this threshold, this amount that says your estate is actually too small for a full-blown probate. So all you have to do on an affidavit is lay out the facts, like who you are, your death occurred, the approximate value, because you may not even know the approximate value you think may be in an account, and then total it up, say who and you can subtract out debt. So you can subtract out mortgage, funeral costs, typically attorney's fees. All that can be subtracted out. And if the number, like in Indiana, it's $100,000 as of July 1st of 2023. Prior to that, it was $50,000. Washington State is $50,000. I think Illinois is $25,000. Michigan just went up to, I think, 50 or 75,000. So every state has this threshold that says your state is actually too small for a full-blown probate. So you just have to wait a certain amount of days to pass before you can sign this affidavit and then present it to the financial institutions to receive those funds. And then you distribute it to the persons that are listed in the affidavit as the next in line heirs of the estate. Now, when it comes to the death certificates, I mean, most people can buy one, right? So your death certificates will range somewhere between $16 to $18 for sure in Indiana. They're usually $20 or less. And so most institutions will take a copy, except for retirement accounts. Most places where retirement accounts are held, they want an official original copy. So if you know that your loved one has 3 retirement accounts, then you know for a fact you're going to need 4 death certificates, because each of those retirement accounts is going to want an original. The bank and all these other institutions, they can take a copy. Same thing goes with life insurance. You typically can scan or fax in a copy of the death certificate. And so it's very rare that you can't at least get one, you know what I mean? And then try to buy yourself some time to get maybe 2 or 3 more. And then just give your family. But if family members say they want original copies, then that's where you kind of get them. Well, you need to pay for your own. Then you need to chip in, give us the $16. But yeah, they're not really too expensive to get them. I mean, $16. Yeah, I mean, I guess it is kind of expensive because it's just a piece of paper. But for the good that how far it can leverage you and get you access to funds, I guess in the grand scheme of things, not as it's I guess you could say Starbucks for 3 weeks, or for 3 days, $5 a day.
Yeah, exactly. So, so we've thrown a lot of dates around: 30 days, 30 to 90 days, up to a year. So when should a family member inform financial institutions or the court that someone has passed away?
Great question. So, if you have a will, you should do it as soon as possible, because wills can be stale, meaning certain states will say after so many years, like in Indiana, it's 3 years. The will be stale, meaning we had a situation. I had my really good friend, her grandfather left the assets to her brother, the grandson, but he had a bunch of children. And so what happens is they probated the will after 3 years. And so the children, some of them, not all of them, they were trying to say, well, that's not a valid will because it's stale. It's no longer, should be followed. Where some of the siblings were like, no, we know this is what dad wanted. We want to honor his wishes. And so sometimes those situations then force the family to either settle, like find a way to compromise, or sometimes the judge may throw it 100%, in line with the law to say you're outside the statute of limitations. And so we're going to ignore the will and just distribute it to the kids because those are the next in line pursuant to the state statute. So to me, it just, if there's a will, you want to do it as quickly as possible if you want to make sure those terms are, taken into consideration. Now, if there's no will, then to get access, you should just wait until you get a death certificate because all they do is freeze accounts anyways. But if you think that there's some bad actor at play that may like take dad's account, card and go withdraw from the account, or they can log in and transfer money to themselves and et cetera, and things like that, then I would say, notify immediately. But a lot of times we prefer they wait. In our practice, we prefer they wait till they get a death certificate and speak to us, and then we can do it from a timing standpoint. We can be very methodical and strategic about who to notify when. Now, when there is a death, the funeral home will notify Social Security. And so Social Security will then snatch back any Social Security check that is not rightfully owed to the recipient. And that sometimes triggers to the banks that a death has occurred. Whenever a Social Security check gets snatched back, that's usually a red flag to them that a death has occurred. And they may, on their own, freeze an account. But typically, you're entitled, as a beneficiary, you're entitled to the month that you lived in. You are entitled to that check. But the closer you get towards the end of the month to get the checks out in time, Social Security will start depositing checks ahead of time, ahead of schedule, even though you're not in that month yet. And so sometimes beneficiaries, well, Social Security took the check. Well, that's because they were ahead. They were running ahead. And so that was next month's check. Your loved one already got the check for this month. And so that sometimes will trigger the institution that a death has occurred, and then they'll freeze the account.
So if let's say I died today, November 17th, and then there was a charge that came through on, the 19th, the 20th, after my date of death, then can the bank, or I don't know, can it be rejected, or?
Yeah, well, you can dispute it if you believe it's an unauthorized use of the card. If it's just something like that's on auto pay, a lot of times the beneficiaries or the representative of the estate or administrator will just let it ride because it was going to need to be paid anyways. Right. But that's one of the first things we do is go ahead and notify. Like if you look at a person's wallet and you see cards in there, then we want to start notifying those institutions that the person has died so people aren't misusing the credit.
Got it.
Is there anything else you'd like our listeners to know about the probate process, trust, and wills?
Yeah, I mean, I feel like the main thing that people should know, one, is there's no real registry where we can dial up where your assets are located. So there's thousands of life insurance companies, and there are companies that say they can research it. But that doesn't mean they're going to find everything there. And where you bank, where your investments are, it could be anywhere. Now, the tax return sometimes is a good indication of if you're receiving any type of reportable income. But if you have a paid up life insurance policy, meaning you're not contributing anymore to the premiums, we may never find that policy. And if you have a very slim bloodline, we don't want stuff going to the state, just because we didn't do a plan. So my urgency and my call to action for your listeners would be to, one, lay out where your stuff is. Where is your banks? Where's your investments? Do people owe you money? who's your mortgage company, who's your insurance company on your house or on your car, because sometimes we get a little return of premium, on those policies if we don't, if we're not keeping that asset. So that way your family's not going on this morbid scavenger hunt to figure out where stuff is, because even if we have to go through probate, it's easier to go through it organized than it is to go disorganized. And then lastly, I would say make sure you're having these difficult conversations with your family about who you want to serve, as well as, when these non-financial assets that you possess, the ones that have high sentimental value, have conversation about who should be getting those items, because sometimes the fights will break out over the stuff, and it may be stuff that has very nominal financial value. And so if we want to have a peaceful, efficient, seamless transfer of the wealth, then having these conversations is very, very important, so that we can make sure everybody understands that this is who's supposed to get what. Because even if they tell you they don't want anything, that's a lie. Yeah. Everybody wants something. So just make a list and share the list, and you'll find out real quickly who you gave the wrong thing to or what should have been on the list. And that will solve all of that. And then don't be aspirational when it comes to people. If they're not good with keeping up with their homework and turning it in on time, don't appoint them over your estate. Pick the right people for the job that you can trust to do and carry out the task in the manner that you see fit. And again, feel free to use teams. You don't have to pick the oldest child or one person. You can go outside of your bloodline and pick families, best friends, etc., nieces and nephews. Pick the best people, but have those difficult conversations and leave a nice roadmap of where your financials are, so we can make it easy on them to sign up for the work. Because that's why they don't want to sign up. They know most people aren't organized. If you're organized, they'll sign up.
Got it. Yeah.
That's
awesome.
That's what we've been trying to do ourselves, and then push people to do it.
Yeah.
Encourage. Yes.
Encourage.
Yeah. Once they see you do it, they'll be more motivated, because it's almost, sometimes when you say, it's easier to see do as I do than do as I say.
Right.
You get more traction.
Well, right. And I know that Honey's been working on a couple of tools that help people to make it easier, because if you look at it and you say, hey, this takes me 10 minutes to do,
right,
then you're more apt to do it than sit here with all these papers in front of you saying,
where do I start?
First? Yeah. Where do I start?
Exactly. Yeah. Exactly. Well, that's great. That's anything to help the people. That's, what you guys are doing is fantastic. It's about just getting the information, the education, so that people can stop, tapping their neighbor and finding out what they did. You know what I mean? And because most of the time, no one tells you the ugly side of the truth. They just tell you the pretty side. This was the nice outcome, but you don't know what they did, what made us end up there may have been a little bit messier than people want to have that, divulge to you. So I'm so glad that you're having this conversation, so people can just perk up and pay attention and hopefully motivate them to take action.
Yeah. I mean, I usually take notes. I do a lot of notes this time.
Well, we want to say thank you so much for sharing today all your expertise, your stories. All of it has been very informative. So would you please share with our listeners how they can connect with you?
Yeah. You can find me on all forms of social media under Norton Estate Planning. Our website is www.estate planners, plural.org. And on there we have videos, explainer videos, and some handouts and things of that nature, hopefully that people can use, and resources that they can use to help themselves. But yeah, you can call our office at 317-572-8696. We do free consultations, so feel free to go to our website and you can book yourself. And I'm happy to answer on a more personal level if you need that type of guidance.
Awesome.
Yeah. We're going to have to pass your number to, I have an aunt that lives in Indianapolis.
Oh, absolutely.
Like,
we'll take good care of her.
We need to get them squared away too.
Absolutely.
So listeners, as a reminder, we always have a disclaimer when we talk to lawyers. Just to let you know that this isn't really legal advice for you. It's important to talk to and consult an estate or elder law attorney in your state, because every state is different. Every situation is different. So please contact somebody in your state. And as you continue to think about the topic today and all the notes I took, I want you to reflect back on that essential question. How important is it for you to have a will or a trust? And it's not always just about the money. It's about some deeper stuff.
Right. Well, until next time, remember, every chapter you write today shapes your legacy tomorrow. Thank you for joining us at Thoughtful Planning. And just like the vibrant hues of a setting sun, we're wrapping up another episode of Thoughtful Planning. Every shared story and insight is a step closer to turning uncertainty into celebrations of preparedness.
Absolutely. And to our listeners, remember that every surprise that comes our way is an opportunity to grow, adapt, and learn. Stay tuned for more stories, expert insight, and of course, a touch of wit in our next episode.
We're not just co-hosts, we're fellow travelers on this journey. For more information on additional resources, which will help you take the next step in planning, look for the link in the show notes for our membership. Join us next time for another episode of Thoughtful Planning. Until then, keep living, laughing, and loving every moment.